How deeply integrated are tribal rights into the core fabric of our Constitution, far beyond just reservation? If one single constitutional change split the entire national mechanism for scheduled castes and scheduled tribes, why was that split so fundamentally crucial?
It's a great question.
We're going to dive into the administrative bedrock for scheduled tribes today, using our stack of sources to prepare you thoroughly. This isn't just about knowing an article number. It's about understanding the journey, the power, and the purpose of the National Commission for Scheduled Tribes.
Welcome back, everyone. Our mission today is really laser focused for you, the learner. We are synthesizing rigorous constitutional coverage, drawing heavily from foundational texts like Laxmikanth's work, and we're linking every single principle directly to what you'll need for the UPSC prelims and mains.
Exactly. We have key analytical linkages, including a direct connection to a previous year question about the fifth schedule.
Right, and we're going to show you how the body we're discussing today, the NCST, is actually the constitutional solution to those deep-seated problems.
Okay, but before we unpack all of that constitutional history, a quick and very heartfelt note from us.
Yes.
We want to give a massive shout out and a really sincere thank you to all of our existing paid members. Your dedication, your support, it is absolutely essential for us to maintain the quality and consistency of this super useful in-depth content.
We truly couldn't do this without you. It's that simple.
And if you're new here or a returning listener and you're finding this valuable, we just humbly ask that you take a moment to subscribe to the channel, smash that like button, and please share your valuable comments below.
And if you are capable, joining one of our paid membership tiers ensures that we can continue and even expand this resource for the entire learning community. I mean, it is the fuel that keeps this deep dive engine running.
Absolutely. We know how critical these resources are, so we want to make sure you have everything you need to succeed.
And on that resource front, there is immediate support available for everyone. Free consolidated notes summarizing this deep dive. And they even have embedded practice PYQs related to these topics are instantly available on our official Telegram channel.
So go grab those right after this. And for those of you who are really committed to converting this knowledge into high marks, our most dedicated learners, there is a premium offering.
Precisely. For our Legend members on YouTube, we have exclusive premium offerings waiting for you on our Discord channel. This includes comprehensive premium notes, extra high-yield PYQs, and professionally crafted model mains answers for critical questions.
Like that challenging fifth schedule question we just made.
Exactly that one. So if you're serious about mastery, that is the resource tier designed specifically for you.
Okay, let's unpack this. Our deep dive today is all about the evolution and the powerful mandate of the NCST. We'll trace its creation from a single, humble special officer, all the way to the bifurcated, powerful, multi-member body it is today. We'll analyze its quasi-judicial powers, which are truly instrumental and critically. We'll examine its function in the context of the fifth and sixth schedules, linking this directly to the demands of the main syllabus.
To really get the NCST today, we have to start at the beginning. You have to recognize that this body is the result of decades of constitutional learning and adjustment.
It wasn't just created perfectly on day one.
Not at all. The mechanisms protecting SCs and STs, they evolved based on a, frankly, painful recognition of administrative need and just how complex society is.
And the starting point, that initial safeguard, it really speaks volumes. Before all the big changes in the 1990s, the mechanism for monitoring safeguards for both scheduled castes and scheduled tribes was just a single special officer.
That's right, just one person. Established under the Constitution, and their mandate was singular but critical, to investigate all matters relating to constitutional safeguards for both SCs and STs.
And where did the report go?
Directly to the present. Think of it as the earliest, most centralized constitutional check. It was a solitary point of accountability, designed to bypass the bureaucracy and go straight to the top.
But I mean, the challenge of monitoring two massive, distinct groups, SCs facing social discrimination, STs facing land alienation through one officer, it just seems impossible.
Well, the limitations became obvious pretty quickly. A single officer, however diligent, just lacked the institutional capacity, the reach, and the expertise required to address the scale of the issues.
It created a massive push for reform, didn't it? Moving away from just one person to a full-fledged institution.
Exactly. And that brings us to the 65th Constitutional Amendment Act of 1990. This is the landmark moment. It's the system recognizing that a more institutionalized, high-level, multi-member approach was needed.
So this amendment led to the combined National Commission for SCs and STs.
It did. This new constitutional body officially replaced that single special officer structure entirely. It was a massive institutional upgrade, a clear signal of a heightened focus on oversight.
But here's the crucial turning point, and every UPSC aspirant needs to understand this part. Even with the combined commission, a fundamental structural problem remained, right?
Precisely. The core issues facing scheduled castes were, and are, significantly different from those facing scheduled tribes.
You're talking about land rights, forest conservation.
Exactly. Tribal populations face these profoundly distinct challenges, and lumping them under one commission meant that these tribal-specific problems were often diluted or overshadowed by the politically and numerically powerful issues faced by scheduled castes.
So this inherent difference became the logic, the rationale for the next big step.
It did. The government recognized that to effectively monitor issues unique to STS issues woven into geography, ecology, cultural autonomy, you needed a dedicated expert body with an exclusive mandate.
And that culminated in the 89th Constitutional Amendment Act of 2003.
A critical date and act to remember. This act formalized the bifurcation. It split the combined commission into two entirely separate independent constitutional bodies. It was a profound acknowledgement of the distinct protections afforded to tribal populations.
And the constitutional separation was meticulously structured. The National Commission for Scheduled Castes, the NCSC, it stayed under its original article.
Article 338.
Right. But the National Commission for Scheduled Tribes, the NCST, was established under a brand new dedicated article, Article 338A.
And the creation of Article 338A is so important. It confirms its distinct legal identity, the specificity of its functions. It's the law recognizing that the tools you need to address land alienation in a scheduled area are completely different from the tools you need to address untouchability in a village.
So if we trace the journey, we start with a single officer.
Right.
The 65th Amendment in 1990 gives us a multi-member commission for both.
Yep.
And then the 89th Amendment in 2003 gives us two distinct high-powered commissions, with the NCST formally coming into existence in 2004. Mastering this timeline is vital.
Absolutely. For both factual prelims questions and those deeper analytical major questions.
Okay, now that we have the NCST firmly established under Article 338A, let's drill down into its internal structure and the substantial powers the Constitution gives it.
It's intentionally structured as a multi-member body. It consists of a chairperson, a vice chairperson, and 3 other members, so a 5-person commission.
And that's to ensure you have a range of perspectives, I assume.
Exactly. It ensures that deliberations and investigations benefit from different high-level viewpoints, making the final recommendations more robust.
And the appointment process itself, it's not a simple government posting.
No, absolutely not.
Yeah.
All 5 members are appointed by the president by warrant under his hand and seal. This is an appointment of real constitutional significance. It confirms their independence and authority.
What about their term? How long do they serve?
The term is typically 3 years, and critically, members are not eligible for appointment for more than 2 terms.
Why is that 2-term limit so important for a commission like this?
It strikes that vital constitutional balance. You know, a 3-year term is long enough to gain deep institutional knowledge, to start complex investigations. But the 2-term limit prevents entrenchment.
So it keeps fresh perspectives coming in.
Exactly. New expertise, new energy, which is essential when you're dealing with such dynamic social challenges.
Okay, let's move to the core mandate, the functions defined in Article 338A. This is where the NCST really goes beyond a typical advisory role.
It's profoundly multifaceted. First, there's the intense focus on investigation and monitoring. The Commission has to meticulously investigate and monitor all matters relating to constitutional and other legal safeguards for STs.
So they're like the state's internal auditors on tribal welfare. But what about when someone has an immediate problem, a grievance?
That's the second pillar. The Commission must specifically inquire into complaints concerning the deprivation of rights and safeguards. It's a direct investigative mechanism. If a community feels their rights under the 5th schedule have been violated, they can go straight to the NCST.
But the function that makes them so integral to national policy is their advisory role. This moves them out of just rights protection and into national planning.
This is the critical nexus. The NCST is constitutionally mandated to actively participate in and advise the union or states on the planning process of socioeconomic development for STs.
So they're involved right from the start, not just criticizing failed schemes afterward.
Precisely. They're there at the budget allocation and program design stage. And then after that, they must rigorously evaluate the actual progress achieved under those plans. It's a full cycle.
And once they have all this information, investigations, evaluations, it all feeds into the accountability structure.
Yes, through reporting. The NCST is obliged to present detailed reports to the president, usually annually, detailing how well these safeguards are working.
Yeah.
And based on these findings, they issue specific recommendations.
Now, let's talk about the real power source of the NCST. It's quasi-judicial authority. This is the part that should make every state official sit up and pay attention. This is what gives it teeth.
Well, what's fascinating here is the sheer administrative leverage they possess. Article 338A grants the NCST the explicit power to regulate its own procedure, but most critically, when investigating any matter, the Commission is granted all the powers of a civil court trying a suit.
That's a constitutional provision that gives them serious legal authority. It's not just advice. This is a key detail for prelims. What does having all the powers of a civil court actually let them do?
It gives them procedural independence and enforcement capability. Let's break down those specific powers, because this is where you see the real teeth of the NCST.
Okay.
First, they can summon and enforce the attendance of any person from any part of India and examine them on oath.
So they can call in a CEO, a top government official, anyone.
Anyone. Second, they can require the discovery and production of any document. In a land dispute, they can compel the Revenue Department to produce original records. No one can claim procedural confidentiality against them in an inquiry.
Okay, what else?
They can receive evidence on affidavits and requisition any public record from any court or office. This lets them bypass bureaucratic delays. And finally, they can issue summons for the examination of witnesses or documents.
So the NCST, when it's investigating, it's almost like a miniature, specialized constitutional court focused purely on tribal issues.
That's a perfect analogy. It's a very potent mechanism. If a community alleges illegal mining on their land, the NCST doesn't have to wait for anyone else to act. They can start the inquiry, compel testimony under oath, and get the records directly.
So let's follow this through. The president receives these powerful, quasi-judicially backed reports. What's the next step in the accountability loop?
The Constitution mandates a clear and public chain of accountability. Once the president gets the report, they are obliged to place it before each House of Parliament.
So it gets immediate parliamentary scrutiny.
Yes, and the president must accompany that report with a memorandum explaining two things. First, the action taken by the union government on the recommendation.
And second,
the reasons for non-acceptance, if the government decides to reject any of the advice. This is crucial. It forces the executive to publicly justify why they ignored a constitutionally mandated body's recommendation.
And this applies to states as well.
It does. Reports related to state matters are sent to the concerned state governments for appropriate actions and accountability within their own system.
Okay, this brings us to the analytical core. How does the NCST's monitoring role integrate with the actual constitutional frameworks on the ground, the 5th and 6th schedules?
The answer lies in Article 244. This article is the constitutional parent of both schedules, and it sets up two entirely separate models of governance that the NCST has to monitor.
Let's start with the 5th schedule.
Okay. The 5th schedule covers most of India, outside of 4 Northeast states. Its framework is essentially focused on protection and adaptive administrative control. The governor has special powers. There are tribal advisory councils, all designed to make sure outside laws and forces don't harm tribal interests, especially land rights.
And this protection-focused model leads us right to that high-value UPSC mains question you mentioned, linking this to internal security.
Yes. The question: analyze the impact of non-implementation of the provisions of the 5th schedule on the growth of left-wing extremism.
This is a perfect example of how polity, governance, and internal security are all connected.
Absolutely. Non-implementation isn't just a legal failure. It's a profound socioeconomic one. It means failure to protect land, allowing illegal encroachment.
Economic disparity, administrative neglect.
Exactly. And when the state, through the 5th schedule, fails to deliver on its promises, when land is taken and justice is denied, what do you think happens?
A profound sense of alienation takes root. Distrust, anger.
And that's the fertile ground, the vacuum that left-wing extremist groups or Naxalites systematically exploit. They step into the institutional space left by the state's constitutional failure and offer a radical, often violent alternative.
So the NCST's core function of advising on development and investigating these deprivations is designed to be the antidote to the rise of LWE.
Precisely. A strong, effective NCST is a long-term internal security strategy. Its success means robust legal protection. Its failure directly fuels the ideological appeal of LWE. You have to articulate that link in the mains answer.
Okay, let's move to the other side of the coin. The sixth schedule. This is a fundamentally different model, isn't it?
Completely different. It focuses exclusively on the tribal areas in Assam, Meghalaya, Tripura, and Mizoram. The rationale here is rooted in preserving highly sophisticated, pre-existing democratic systems.
So the key difference is the emphasis on self-rule rather than just protection.
That is the essential distinction. The sixth schedule empowers these communities with substantial autonomy through autonomous districts and regions. These bodies have legislative powers over land, social customs, even some judicial powers.
So the NCST's monitoring task is suddenly incredibly complex.
It is. It has to ensure compliance with a model focused on centralized protection in fifth schedule areas, and a model focused on radical grassroots autonomy in sixth schedule areas. They have to be both a protector and a facilitator of self-rule. It's a tightrope walk.
And this entire structure, both schedules, is ultimately underpinned by the directive principles of state policy.
We always come back to DPSP Article 46. The state must promote the educational and economic interests of SCs, STs, and other weaker sections, and protect them from social injustice and exploitation.
The NCST is the institutional mechanism designed to make that DPSP a reality.
Exactly. It transforms the abstract concept of a welfare state into concrete, monitored action. Without it, Article 46 would largely remain an aspiration.
To really appreciate the strength of the NCST, we need to place it in context. The difference between a constitutional and a statutory body. That's a classic prelims question.
It is. And it's not just academics. The NCST, under Article 338A, is a constitutional body. It's established directly by the Constitution. That gives it supreme legal standing.
We need to contrast this with other important commissions.
Right. Think about the National Commission for Women, the National Commission for Minorities, the National Human Rights Commission. All are vital, but they are statutory bodies.
Meaning they were created by an act of Parliament.
Exactly. Which means they could potentially be altered or dissolved by a simple legislative majority. The NCST requires a full constitutional amendment.
That constitutional backing insulates it from simple political pressure.
Yes. Another critical area where the NCST provides a check is on the governor's special powers in scheduled areas. We said the governor can modify or block laws from applying there.
Which is a necessary safeguard, but also a huge amount of power for one person.
Precisely. And that's why the NCST is so essential. It provides a necessary, constitutionally mandated oversight of how that executive discretion is used. It ensures the powers meant to protect are not misused or neglected.
We can also see its role in the bigger picture of national coordination.
Absolutely. The issues it deals with, development, land disputes, often cross state lines. This naturally connects the NCST's work to bodies like the Interstate Council under Article 263.
So the NCST's reports provide crucial specialized input for those high-level policy discussions.
Exactly. Driving cooperative federalism towards achieving those DPSP goals.
Okay, let's distill this into strategic takeaways for a UPSC aspirant. What needs to be underlined?
For prelims, you have to know the sequence and the legal anchors. The NCFT was born from the 89th Amendment Act 2003 under Article 338A.
And its powers are equivalent to a civil court.
Yes, and lock in the distinction. NCST is constitutional. NHRC, NCW, NCM are statutory. Those are high-frequency facts.
And for mains?
For mains, you need to be analytical. You must articulate the profound difference between the fifth schedule protection and the sixth schedule autonomy and self-rule.
Analyzing why these two models exist is just as important as knowing what they are.
And most critically, use the NCST as the institutional bridge. The analysis of the link between the failure of the fifth schedule and the growth of left-wing extremism is where the NCST shows its true relevance. It's a check on government performance.
Okay, as we wrap up this deep dive, let's circle back to that central tension you mentioned earlier, something for our listeners to think about.
Right. The NCST has to oversee two fundamentally different constitutional models. The fifth schedule, which is about protection from the outside, and the sixth schedule, which is about autonomy and self-rule from within.
That is the core dilemma, isn't it? How effectively can a single national commission reconcile that tension, that need for centralized oversight for protection, and the constitutional commitment to genuine grassroots tribal self-rule?
It's a huge challenge. So here's the thought to leave you with. If you were tasked with policy reform, what specific adjustments might you recommend to further empower the NCST to achieve both protection and autonomy simultaneously without diluting either one?
That's the kind of critical thinking that takes a mains answer from good to exceptional.
Exactly.
On that note, we have to once again say a huge thank you to all our dedicated existing members. You are the ones who power this platform. We encourage all learners to subscribe, like, and share to support the channel's mission.
And don't forget, your free notes and practice PYQs are waiting right now on the Telegram channel. For the full deep dive, model mains answers, and that premium content, make sure you are a legend member on our Discord.
Thank you. This deep dive into Indian polity and the administrative fabric protecting our scheduled tribes. We look forward to guiding you through your next essential subject very soon.